I wanted to give a shout out to Judge Bonnie Goldstein, who organized, along with the Dallas Bar Association sponsoring, and Dallas Abota, thank you, Quentin Brogdon, also sponsoring, both at Crowley and at George Allen courthouses. Every day this week, the juries have come in Monday through Thursday. There has been coffee and donuts and water, and Judge Goldstein has been up there at the microphone letting these jurors know how much we appreciate them. And it's been a wonderful atmosphere in the jury rooms, and they've already been sending comments and suggestions to Judge Goldstein, one of which I just heard, which is a wonderful suggestion. So thank you very much, Judge Goldstein. And along with Judge Goldstein, Judge Hoffman and Laura Benitez Geisler are leading a committee that is working on jury improvements in our courtrooms, our central jury rooms, like Wi-Fi and charging stations for folks and their phones and so forth, to improve that experience. A couple of save the date announcements. June 29th here at the Belo Mansion at 11:30 will be the first ever naturalization ceremony. If you've not participated or seen a naturalization ceremony, it's one of the most humbling, wonderfully gratifying experiences to see our new citizens sworn into this country. We will have lunch at 12 o'clock following the ceremony. The lunch for those new citizens and their family members will be taken care of, and we invite you to come sit down with them and just really introduce yourselves and welcome them as new citizens to our country. Finally, wanted to mention to this crowd especially Bench Bar Conference this year, October 5th through the 7th. We're changing up the format quite a bit. It is going to be really non-practice area specific. We're going to have Kimberly Papillon, an international speaker, on the neuroscience of decision making in the law, which is a very cutting edge topic. It'll be a workshop on Thursday, and it's usually a $20,000 price tag for Ms. Papillon, but we've got that worked out, so if you're an attendee, it's just part of the package and free for you. We're also going to be outside for all of our meals, and we're going to utilize the lake for the first time, and it's going to be a wonderful experience. Our judges are going to lead our breakout sessions, so we expect a good time. Y'all have a wonderful program today. Thank you, and welcome to the Belo.
Hi, yeah, thank you very much, all of our sponsors and our hosts. Their names are featured up there on the screen. I also want to thank all of the attorneys who are here to learn more about how juries can be improved, and of course, all of the jurors. So I'd actually like to start out with asking the jurors to stand so we can all acknowledge them. Thank you. Thank you very much for your service. This is Jury Appreciation Week, which was recently signed into law by the Texas legislature just 2 years ago. This is only the second Jury Appreciation Week, and we're very excited to be a part of it. My name is Richard Jolly, and I work as a research fellow for the Civil Jury Project at the New York University School of Law. We held one of these events about 6 months ago with our executive director, Steve Sussman, as host. Unfortunately, he could not join us today as he is still practicing law full time and is handling a trial actually in Delaware. But I think we're gonna do all right. Hopefully. Thank you very much. The Civil Jury Project is an academic institution at NYU Law School that focuses on bettering and improving jury service around the country. As some in this room may know, but perhaps not everyone, civil juries in our country are disappearing. Back in the 1960s, the percentage of cases disposed of by civil juries in federal courts hovered around 5%. That number today is around 0.6%. And there are a number of factors for that, some of which we have been studying through our empirical projects, and some of which we've been learning about through talking with attorneys and judges. In fact, one of the big empirical projects we've been engaged with is a survey of attorneys. We actually just finished a survey of over 1,000 attorneys, asking them why they thought juries were disappearing in this country. We are following that up with a survey of judges to ask them why they think juries in this country are disappearing. We think that the results and the juxtaposition there will be rather interesting. Lawyers tend to think that the judges are responsible, and judges tend to think the lawyers are responsible. And more importantly, we're also asking regular people why they, or if they're even aware that juries are disappearing. Our hunch is that they are not aware. The media is very, very successful in convincing people that there's a litigation explosion in this country, with coffee spillers winning millions and doctors losing practices. And we are interested to learn if that is the way that the average person feels, or if they're even aware. We are working with the American Society of Trial Consultants to administer that survey, and we should have those results coming in the next few months. In addition, we've been engaged with a couple of professors from Baylor Law School in analyzing what are called 8K contracts. These are material contracts between public corporations that are material enough that they have to be filed with the SEC. What we did was we analyzed every contract filed for the first 6 months of 2016 to find out how many of these contracts had jury waiver or arbitration clauses in them. Our hunch was that those numbers would be pretty high. One of the common complaints about jury trials is that they are expensive, that they are unpredictable, and sophisticated business-to-business transactions, one would suspect, would waive out of jury trials. What we found was somewhat surprising. Those numbers are actually pretty low. About 60% of these contracts do not have a jury trial or an arbitration clause in them. This is surprising because we think that what we surmise from this is that juries add value to these contracts, that these are sophisticated parties who are dickering over these contracts quite closely, and yet they are deciding to submit their disputes to juries, which is fantastic to hear. We are now in the process of contacting some of the general counsel responsible for negotiating these contracts to discuss with them whether or not our hunches are accurate. Finally, there's something I wanted to bring to your attention because it's rather topical and interesting. Just a couple weeks ago, Judge Gorsuch became Justice Gorsuch on the Supreme Court, as you know, and he's actually, as you might not know, a huge proponent of civil juries and of civil justice reform. In fact, if you look at the screen, I don't know if you'll be able to make it out, but this is actually a memo that Justice Gorsuch wrote to a few judges around the country where he proposes the federal court shifting from a default non-jury rule to a default jury rule. That is, right now, if you go into federal court and you do not request a jury, you waive your right to a civil jury. He proposes it to be more like the criminal jury, where you have to affirmatively waive that right. You have to affirmatively waive a civil jury in order to lose it. He says that there are a number of reasons that animate this proposal in the memo. Number one, he says we should be encouraging civil jury trials. Number two, he says that simplicity is a virtue and that the new rule would produce greater certainty in those who are litigating, particularly when they are changing venues. And third, he suggests that this new rule would honor the Seventh Amendment more fully. And whether or not states start to pick this up, it's still a very interesting proposal, and it's interesting to see somebody at the highest court making these types of arguments. So we were excited to bring that to your attention as well. So before I invite everybody up on stage, I want to acknowledge that we have a number of judges here today that have helped us put together this event and that will be participating on the panel. If you could stand up, please. Judge Davis, Judge Ginsburg, Judge Goldstein, Judge Hoffman, and Judge Williams. Thank you. And now if I could invite the judges whose names are up here on the panel, as well as the jurors who agreed to participate on the panel as well. It appears that some of the jurors who had agreed to participate on the panel were unable to make it, but we have others in the audience. If there's anybody that would like to come up and talk about their experience, I promise you it's not a pop quiz. It's the questions are easy. It's really just asking you about how you felt about it. Please, please.
Can I say something? I've tried over 200, probably at this point over 250 jury trials, and this juror was one of my liveliest jurors on a 7-week trial, and she had a great attitude the entire time.
Great.
9-week trial. The It seemed like. How long was it, Michael?
Are there any other jurors who would like to come up? Really, it's not. Over here? Anyone? It's really a lot of fun. It's not hard.
Get your other juror.
All right, well, it's fine if you don't either.
Yeah, let's get one of the.
Judge Hoffman's more persistent.
Yeah, you know which one he's talking to. Come here.
Please come. Everybody, give him a hand.
I promise I showered. Clear up.
Oh, you're here, Claire.
Oh, I tell you, why don't we switch then if we know you're here?
Supposed to be.
You are here. Look at you.
Your name and lights.
So if I could start out with asking the jurors just a question about how long your trial lasted and whether you sat on a criminal or a civil case. Maybe we could just go down the line. And I'm sorry, please speak up. We only have a few mics, so.
Good afternoon. My name is Wheeler Holt. I sat on a civil case. It lasted 1 day, and I got lucky. And I had the Honorable Judge Goldstein. So.
Great.
My name's Gary Cook. I was on a civil trial, and it lasted around, what do you think, 10 days?
About
Claire?
3 weeks.
3 weeks, was it?
3 weeks.
I was released a little early, but
Okay.
And I'm Linda Hedden, and I sat on a trial that lasted 9 weeks.
Okay. And,
Claire Manigault, and I sat on a civil trial, and it lasted 3 weeks.
okay, so this is really interesting. We have quite a disparity in from 1 day to 9 weeks to 3 weeks. That runs the gambit. So let me ask then, when you first received your summons in the mail, how did it make you feel? Were you anticipating something like a 9-week commitment? Were you anticipating maybe a 1 day? How when you got that, what was your maybe emotional response and what you thought about it? Gary, how about you?
I was expecting not to be selected.
I'm sorry, what?
I was expecting not to be selected.
Why were you expecting not to be selected?
Because I'm very conservative, and usually jurors they want jurors that are more.
Was that your experience had you been called for another
I've been
jury?
called before, yeah, and not picked. Mhm.
Okay, anybody else have a similar been called and not picked?
Same here, because I did not give a whole lot of information toward the questions that were being asked. So.
Okay.
I had been called about 4 times previously and served twice, so statistically, I didn't think I would be picked.
Okay.
It had been a long time since I had been called, and of course, when I received mine in the mail, I go, oh, no, and I deferred it.
Okay.
Because it was a busy time at work, so I deferred it. And I actually picked the date that was between Thanksgiving and Christmas, because I thought, oh, nothing will happen between Thanksgiving and Christmas. And I was wrong.
In Texas,
And I knew I'd be
mistaken,
picked.
you can switch the date that you'll be called on. You can do this online. Is that correct?
Yes, I went online and did it.
That's great. That's great. Did anybody else switch when they were? So okay,
I had to delay mine,
you delayed as well.
Yes, I switched.
not for the same reason.
Exactly. I switched my date, and I was able to pick the location I wanted to go to.
Oh, that's really great.
Can I ask the jurors a question? A lot of you all talk about being picked. Was it ever explained to you, maybe either during the jury selection process or afterwards, that the way it works is you actually don't get picked, but you just get you fail to get
We get
stricken?
not-
Is that what not deselected?
Non-deselected, exactly.
Was that ever made? Are you just learning that for the first time now? Well, I knew there was something like that, but I'm very curious about the details of how that works. Yeah.
Judge Goldstein kind of alluded to the terminology, the way she phrased it.
Process of deselection, non-selection.
Right.
Real quick, you're seated randomly. First 12 people get picked or get on the jury, absent strikes. And so the reason why they ask you all questions is if somebody says something that gets them stricken, I've already made up my mind. I'm already leaning towards one side. Well, then you get stricken, what we call in legalese, for cause. And then after the judge, so when you're out in the hallway, that's what we're doing. So they're saying, I want to strike Claire here for cause. She said, she's already made up her mind or something like that. And then after that, each side has 6 strikes for pretty much any reason whatsoever. Not quite, but more or less. And then the first 12 people, that's your jury.
I have a question I'd like to ask.
Please.
Of the jurors who serve from 1 day at the least up to, I think, 9 weeks, having sat through the jury trial, what is your opinion as to whether you would have liked to have served more time, which I doubt, and heard more evidence, or how much time should that case have taken given its complexity and the evidence and the issues in it versus how much it actually took? And I know yours just took 1 day, so you probably wanted more time, right?
Well, no, actually, it could have taken less time. Based on the information that was presented to us, it actually could have taken less time.
I think it was pretty good for the amount of material that we had to go to. I would not have wanted it to be longer, that's for sure.
For us, it was the first week or so, we were kept thinking, okay, let's get this over with. And then we were really spoiled. Judge Hoffman is just wonderful to be a juror for. And we had gourmet lunches. Every one of our little needs was accommodated. It was amazing. And by the ninth week, when we found out that they had settled out of court, we were almost like lost, because it was like, wait a minute, we come down here every day for 9 weeks and we've developed a pattern, a lifestyle, and we have to go back to work.
Let me say something about that case, and thank you for the kind words. That case actually, I'd had 100 hearings, over 100 hearings on the case. The case had gone to mediation 9 times. The trial lasted 9 weeks with a fantastic jury. How many people are from the Cornerstone case? I know there's some other jurors who are here. That was a fantastic jury. And then I got a call from the mediator the night before the original closing arguments were scheduled, and was told the case settled, but could I bring the jury back 2 days later? I'm like, they've been here 9 weeks, you want me to bring it? I'm like, okay, we'll bring it back 2 days later. And then they called me again and said, no, can you bring it back next week? And I thought for sure when we said we had to delay that for a whole week, the jury would be really angry. And they were all laughing and joking like they were like old friends got back together. And they were really sad when they heard the case had settled, because they really wanted to, I don't want to, but is that pretty accurate that they really wanted to deliberate?
I think some of us were willing to become professional jurors.
And I will say that I've tried a lot of cases. That is not the typical experience. It was one of the best tried cases I've ever seen. Mr. Hurst, who's out here, was one of the lawyers. He did a fantastic job opposing counsel on the case. There's some fantastic lawyers. It was just a really, really well-tried case, and they made sure that the jurors were also taken care of with lunches and stuff like that, and did a wonderful job. So I'm glad to hear that you guys had a good experience.
We did have a good experience.
That is really great to hear. Before we jump fully into the time, I'm really interested with somebody, for instance, you had said that you hadn't been impaneled before, perhaps because of your views. Other people thought maybe they wouldn't get, they would be deselected, as we say. Something like a 9-week trial is so intensive. Was that something that I imagine they brought up to you in the questioning at first about how long the trial might last, perhaps?
Judge Hoffman alluded to the fact that when he had us originally in the room, he was like, now this is going to be a really interesting trial, so if there's ever a trial that you want to get picked as a juror for, this is it. This is the one you need to go for. This is going to be great.
And he said that to us.
Yes. I think it's a standard
Way to
statement.
sell it.
So, I'm thinking, and he said, now it's going to be a bit of a commitment. And I'm thinking, oh, I hope I don't get picked. I hope I don't get picked. And he said, when we initially got picked that evening, we had one gentleman that refused to serve on the jury, and I thought the judge was going to have to send him to jail.
Yeah, that was unfortunate.
But we kind of settled down. We're like, okay. And we're thinking, okay, 3 to 6 weeks. And he says, a minimum of 6 weeks. And we're like, so it is a huge commitment, and it is a lot of time out of your life.
Did any of you maybe consider hopefully not, but maybe excuses. Some people tend to think that they might be able to get excused based on pretend beliefs or made-up hardships. Did anybody think about doing that?
Can I tell a story real quick about that juror, though? Because I think it was a great story.
Okay.
So we was at a 2-day process where we selected a jury. This juror had claimed a hardship. I mean, and we didn't give it to him. And he was seated. He had just started a new job, and he goes, "Judge, I am not going to serve. I refuse to serve." And I told him, "Look, you know, I won't say exactly what I said, but essentially, you can do it from home or from somewhere else," and he didn't like that. And then he calls in the next day, and I was really worried about this juror because he was very angry. He had made it very clear he did not want to serve on this jury. He calls the next day. The attorneys were there we had the day off, and then we were starting trial the next day. The attorneys were there. I brought him into the office, and he says, "Judge," and I was bracing for like, this guy's going to give me an earful, and he goes, "Judge, I just want to apologize about how I acted yesterday. That's not the kind of man that I am, and you're not going to have another problem from me for the rest of this trial." And I will tell you, we did not have a problem with him for the rest of the trial. He was actually a leader. He helped organize the lunches.
Yep.
I mean, he did all this stuff. And so it really kind of, people always criticize juries, but I will tell you, my experience with jurors is once they're selected, they give it their all. And he was a perfect example of that.
Absolutely, yeah, that was something I was going to bring up, is that it seems that those people who actually serve tend to have just fantastic reviews of their service and their experience, versus those who show up and get sent home without actually doing anything, feel like their time was wasted. It's a remarkable juxtaposition there. And I was wondering if maybe when you were selected, if you were maybe excited to start the trial, to see what it was all about. Does that ring true maybe?
Well, with the situation, my boss said before I left, he said, "Well, call the office before you get released." And I was thinking to myself, I know I'm not going to get picked. So I had to call the office at 12. He was thinking I was calling in to say, "Well, they didn't pick me." And I was calling to tell him, I said, "Hey, I got picked. Thank you for your lucky words of encouragement." He was like, "Huh?" I said, "Yes, I got picked based on your luck." So with that being said, I hadn't sat on a jury probably in over 15 years. And it was a civil case then that I sat on. And once again, I with the accommodation that Judge Goldstein gave us, I was shocked and amazed, and with the processes have been updated and changed, I had an excellent experience, being only that I only had one day though.
Can I ask a follow-up question to the jurors? He was mentioning the difference between jurors who served on the actual case versus those that went home. Now, obviously, all of you have served in a jury, but have you ever had a prior occasion where you came down to the courthouse, sat on a panel, and didn't make the jury? And what were your general impressions about that? And then something that she was mentioning, have any of you or some of your co-jurors felt subtle or not so subtle pressure from your employers to not be on the jury?
I had not been selected before. One time, it was a criminal case, and when the jury's panel actually walked into the room, the person on trial agreed to, he saw, "This is real. I don't want it to go to jury. I will plead guilty." Another time, I wasn't selected because I knew the judge. Our sons were friends. And actually, that case, I thought, that sounds kind of interesting. I might have enjoyed that one.
He was saying that some jurors in that situation felt like their time was, did you feel that way?
No, I didn't feel like it was wasted.
One of the refrains that we hear actually is that those who don't serve dread serving, and those who do serve say that they'd be willing to do it again. There's a communitarian and democratic feeling that they get. For instance, people who serve on juries are more likely to vote. They're more likely to be filled with that type of civil, more connected to their community and to their fellow citizens. And so, but that only happens through the act, honestly, through deliberations. That's what the data shows, that it's that process. It's not just sitting there and listening. It's talking with each other and actually coming to a conclusion that affects real people. It's a very empowering feeling. And Those who get sent home, they're like, I showed up, a number got called, I went in there, people asked me weird questions, and then they kicked me off. And that doesn't have the same democratic appeal, I guess. And so, while that might not have been your experience, that some people have said that. I don't know if other people have felt that way, or if when you had, now that you did serve, if you think about jury service differently than in the past when you hadn't served.
Well, I've had a couple of coworkers that do feel that way, that, you know, that did want to serve, and that's just the process that they were deselected and were willing to serve. That, you know, they sat through the time and just knew it was going to be a lengthy process and still wasn't selected.
I think it's very common in Fort Dyer when you're sitting there waiting for selection, there's a lot of buzz in the room and a lot of people are sort of talking about how they can get out of this. I've been selected twice, and this particular last time, the third time, I was ambivalent about being picked because there's so much going on at work. When I got picked, I was surprised, but in the end, even though I was a standby juror, I found it very interesting, and it was a good experience and a reminder how important and how good of an experience it is.
Absolutely.
I've always been willing to serve. I mean, I've gone to several times and not been picked, or had the court call me and say that the case was settled before it ever got to that point. But after this time, the 9 weeks, and it was an extensive thing to go through, but I would hope that the people sitting in the courtroom waiting to see if they're going to be picked would stand up and be good enough citizens to do it, and do it with a servant's heart, because you're looking at people's lives that you're going to change when you're a juror, and you should be really respectful of that and really thoughtful of the process. And it's just like becoming a U.S. citizen. You know, it is a process you have to go through. I would be willing to serve again. I would probably say that it would be tainted from the fact that I probably wouldn't have a nice judge like I had this time and as much fun with the jury as I had. But I would do it again in a heartbeat.
Yeah, I would have a different attitude going in. I think the last time I thought, oh, please don't pick me, please don't pick me. And then I was also an alternate. But it was a good experience, and I would have a different feeling going in this time. And I agree, we had a wonderful judge who brought us blankets and breakfast and all that. So I probably, too, would be tainted.
It's a very interesting thing that you guys served for so long and still have such positive experiences. A lot of people are worried about taking time, missing work and how long the case will last, be it one day. A lot of cases can be resolved more quickly. Some lawyers are, none of these lawyers, of course, but they're long-winded. They tend to repeat themselves. And one way that some judges respond to that is by setting time limits. They either will impose time limits on the lawyers, or they'll ask the lawyers to get together and set their own time limits so that the case can kind of move along more smoothly. Is this something, were there time limits maybe in your case? Were you informed about these? Do you think it would have been helpful? Were the lawyers very repetitive about what was going on? Did you feel like it wasn't moving as quickly as you would have liked?
Oh, you got to tell the story. There's a great story about this.
In our case, yes. There was, and I won't name names, but there was an attorney, or actually two of them, that kept going over the same thing time and time and time again. And so when we were back in the jury room, we were laughing about it, saying, you know, we've got it, let's just move on. And so we came up with the idea of, you know how they used to have the old funeral fans, you know, the little cardboard fans on the stick. Well, one of the ladies in our jury group made those sticks, and on one side it says, move on, and the other side we put, we got it. And we held them up in court.
That's one I haven't heard.
True story.
That's one solution.
We actually did it to the judge when we came back from lunch, and he was about to start. We go, Your Honor, can we interrupt you for just a minute? And then we held up, you know, got it, and turned him around on the other side and said, move on.
I told them they couldn't do that.
No, yes.
Let me chime in on that.
Yes.
Many years ago, when I was an attorney, I was trying a case here in Dallas in front of Judge Marshall, and the case had drug on much longer than it should have, and it was during the Iranian hostage crisis, where everyone was tying yellow ribbons around trees. and to show support and that type of thing. And the jurors came back from lunch one day, and they all had yellow ribbons on. And so the judge inquired about their yellow ribbons and that he noticed, and something about, is this in regard to the Iranian deal? And they said, no, Your Honor, we're tired of being held hostage.
So I guess then, obviously repetition isn't very helpful. It's annoying, it makes everything go on too long. Was there anything else that the lawyers did? We'll start this way. Was there anything else the lawyers did that you found not very helpful? I'm sure people would like to learn about that.
In our case, they had a board that they kept showing in court, and they'd stand it up, and it would block people's views, and it would have timeline. And I appreciated it to start with, but then after about the 6th week, I was tired of seeing it. You know, I had gotten it, I'd figured it out. Plus, a lot of times in courtroom, the things that they were trying to show us were so out of focus, we could not read the projection. So it was troublesome, but yeah. I think a few less, I'm trying to think of how I want to say it, a few less gimmicks to show us, you know.
Yeah, the use of technology or images like that either weren't working or they were overused.
And then one of the other ones would have a flip chart and a right on here. So yeah, it became annoying after a while.
Gary, well, you looked like you had something to say also.
The plaintiff in our case, plaintiff's attorney, presented some data that, and he jumped around quite a bit, and it was difficult to follow. It was electronic records or copied records, and it was just hard to follow some of that data.
It was medical records and medical records and medical records and medical records, and going over and over and over, and then all these records were in books on the judge's desk, and they said, all these will be available to the jury during deliberation. And of course, they had taken anyone off the jury that had any knowledge of how to read medical records, any doctors, any nurses. None of us would have known where to even begin in that. So.
Can I ask a follow-up? And that made me think of something. In your, many of you were on lengthy trials, so you probably had a lot of exhibits back in the jury room. Did you spend a lot of time pouring through them?
They weren't in our jury room.
No, okay, they never got to
We didn't
none
get
of
to,
these-
we
none of
didn't get
these
to
three jurors
deliberations.
Never got to deliberations.
Okay. Well, did anybody deliberate? You deliberated?
Oh, yes, we actually did look at the records. We looked at the records, took into consideration the pictures, the diagrams. We looked at the bill, the medical bills.
Did you spend a lot of time going through the details of them?
No,
Okay.
we kind of just all kind of perused through it. I remember actually looking at all of them and looking at some of the charges were kind of like inflated.
When you were doing that, were there some of your fellow jurors who really looked at details in the records and said, like, well, look at this, and this isn't something they mentioned in trial, or did any of that take place?
Well, we did certain things that were amiss that we did not understand why, like some of his family members, why they did not show up, like his ex-wife that was also a part of the lawsuit that he was suing on her behalf because he was in her vehicle. But she was not there. His sons that were also in the car at the time, they were not there. So it was like certain questions that we were wondering why they were not there, but just him by himself that came up.
Can I ask a quick question? So that's a very good question. We have some jurors in the audience from the Pennsylvania rehab case. Can you guys stand up real quick? I think that's a perfect question for you because the Cornerstone case never went to jury deliberations. Your case did. Did you guys pour through the records like he said? Because that was a very record-intensive case.
By the time we got to deliberations, we had seen up on the screen and heard the plaintiffs and seen the plaintiff's evidence so many times that by the time we got to deliberations and were presented with that giant cart, we really didn't need to go through it. We were a bunch of note takers, so we had copious notes and we knew what the evidence was.
I would agree with Carolyn. I think maybe if there was more dissent between the jurors, maybe we could have gone back to the exhibits to just double check against notes. But, you know, we were all pretty much on the same page once we got to the jury room.
Similar question. At any point, did you actually or contemplate asking the judge to, well, we'd like to hear this testimony and have it read back?
Thank you. Under no circumstances did we plan to go back and ask for any witness to come up to the stand. There was so many conflicting evidence there, and we felt that the plaintiff did not connect his evidence to the root cause of why they were there. So a lot of us had background in law and our jobs as well, so we were able to kind of explain different perspectives. And one good thing that I experienced from this was that everybody's voice was heard. Everybody's experience, thoughts was out there. We actually allowed everyone to give a different spin. And I probably was the one who probably threw a lot of stuff out there because I was a note taker. So I threw a lot of stuff out there for us just to think about. But overall, we were on the same page in a very good experience. I do want to say this because I have a presentation in 35 minutes. But I do want to say, for me, I did not want to be on the jury at all. I kept raising my hand, but the lawyers kept looking past me. And I was ready to debate, say, no, I disagree with this. But after I actually got to experience this, I heard the case, and I have experienced the same thing as the plaintiffs. I actually took my experience and turned it into positive. I actually help people who have a family member in nursing homes and help them through the process. The judge explained the case law that applied, and so I'm able to explain that to people. So I kind of turned this around for myself, and so I hope that other people would take the experience or get the opportunity to serve on the jury duty because you learn more about yourself, about the law, and about others. Thank you.
Can I make,
Can I ask another question, maybe along, those who deliberated, how did you go about picking your presiding juror? I've always wondered that.
We could start with down here, I guess. Right.
Yeah, I mean, I think for us, it was a pretty simple process. I think we had one person in the pool, David, who had previous just law experience going through this sort of thing already. So it was pretty easy choice for us.
Anybody on the panel?
We had actually a licensed attorney, so it was a given.
Can I just make one quick comment? I invited two juries to this panel, or to this discussion. One of them was the Cornerstone case, which was tried, I think, magnificently by both sides. It was very smooth overall, despite the squeaky markers, I guess. But overall, I thought it was just the paragon of the way it should be tried. The other trial, I think the jurors would agree, was a little bit rougher at times. Is that a fair description? And so I was curious to see what their experience was going to be. It doesn't surprise me that Linda says she had a good experience. The other trial was, I thought, kind of a tough one to watch at times and was not always smooth. So, and I didn't know how many other jurors would be here, but I think it's interesting to kind of know that.
Can I add something to that?
Absolutely.
Our biggest problem when we started the Cornerstone case was the fact that we had a host of people in the courtroom. We couldn't figure out which one of them were attorneys, which one of them were the defendants. And we actually asked the judge if they could produce a sheet of paper with people's photographs on them and who and what they were. Because we had how many defendants in that case?
ask Mr. Hurst.
Mr. Hurst, how many defendants were in that case?
Wow.
Including corporate defendants and what have you, I think it started off with 6 or 7, and then a couple settled during the trial. So, but I think there were originally the 5 former employees and the 5 corporate defendants, and then a couple settled right before trial, a couple settled during trial. So probably about 8, but there were a lot of other witnesses, if you will.
Exactly.
That kind of got Jala to ask for pictures of, so we collectively, both sides, put together a photo glossary, if you will, of all the witnesses and parties in the case.
Yeah, so we could keep it straight.
So the photos, you guys found those helpful in helping to keep everything straight. So I asked earlier some of the things the lawyers did that maybe was annoying to you. Was there something that the lawyers did that was helpful, the images of the people so you could keep people straight? Was there other things that you think really helped you out, either in paying attention, keeping track of everything during the case, or later in deliberations you realize, oh, when the attorney was doing that helps me now in making a decision?
I think in our case, both sides, both the groups of attorneys were very accommodating to us because if we had a problem in the courtroom, we'd get the judge's attention and would say, we can't see because of this, or we can't do this, or whatever. And the attorneys started then, when they would start to present something, they'd turn around and go, can everybody see this, or is everybody okay? And made sure that what they were about to present, we could actually gather and hold.
Gary?
Plaintiff's attorney in our case, one of them was very slow, slow talking. He acted slower than he probably was. That probably didn't help things. What do you think?
Well, we had a lot of drama, so you had to kind of cut through the drama to get to what are the facts past some of the drama, I thought.
There seemed to be some
attorneys and witnesses.
Yeah.
Can I ask you, for those another deliberation question? When you all went back into the jury room, did you all take kind of what I'd call an initial straw poll vote and then start discussing before doing your final votes, or did you not do an initial straw poll vote?
Claire and I were standbys, so we can't comment.
Yeah. I know some here and.
No, we did not. It was, by the time we actually went back, I think mostly our minds were already made up, pretty much.
Okay.
Speak up. Yeah, for us, I think what we did is we tackled the issue that was most on the extreme side. So basically, like if you agreed with this and then basically worked back to maybe the points that were a little bit more contentious. So I don't know if we did a straw poll. I think we may have on the most difficult issue, and then we basically are the most easy to agree upon issue, and then we kind of went from there. So I think we all agreed on the easiest issue, and then we basically moved on and just tackled each issue kind of going backwards.
Speaking of deliberations, one of the things that the Civil Jury Project has been looking into and somewhat encouraging people to experiment with is allowing jurors to discuss the evidence prior to final deliberations. This is actually common practice in Arizona. What happens is when you guys are all together in the jury room waiting to be called in, maybe in the morning or during lunch, as long as everyone is in the room and everyone agrees to participate, you're welcome to discuss the case and encouraged and strongly encouraged from coming to a conclusion about the evidence. Please don't tell us if that's something you did in your case because it's prohibited from, that's not allowed to happen in Texas. Although about a decade ago, the Supreme Court of Texas proposed it as a rule change. Arizona's had great luck with it and other jurisdictions are also looking at it. Is this something that you think would have been helpful, maybe, or is it something that you don't think you would have been able to wait until final deliberations to start coming to a decision? Paquella, you mentioned that by the time you guys all got in the room, everyone had already decided, had made up their minds anyways. There wasn't much deliberation.
It was not, because based on the evidence that was presented to us, it was a pretty much cut and dry case.
During the 2.5 weeks I was there, I found myself waffling at times back and forth. I'm glad that, well, had it been possible to do so, what you're suggesting, and I did, had I done that, I would have regretted it because I waffled. And in that case, I think I would have been better off just keeping my thoughts to myself instead of expressing an opinion.
Absolutely.
I think in one case, it probably would have helped from the standpoint that it would have let us be a little more focused as a group.
That's one of the benefits, is that it keeps people more
Exactly.
engaged.
And,
Yeah.
and it would also have helped us weed out problems that we would have encountered had we gone into deliberation. Because it's like, we would see if we're all playing on the same page, or maybe you would give me a thought that I hadn't thought of, and I can go, well, I can start thinking about that too while I'm listening. And I think it may have been a little bit more helpful as long as we were in trial. Because after, I can see 2 or 3 days not being that difficult, but after 9 weeks, you're like, okay, now did I really hear that? Or, how do you feel about this? So, yeah.
Absolutely. Absolutely.
For a longer case, it probably would, like you said, would probably be a good idea. I do wonder what would happen if you had strong feelings on both sides, jurors. Would you start arguing too early amongst yourselves? I don't know.
I don't know either. I haven't been able to be in the rooms in Arizona, but it's an idea that's been kicking around. Have any of the judges, I mean, you probably haven't done this. I imagine with the lawyers, if they consented to it, you might. Is that something that, let's pretend 2 lawyers consented to it. Judges, is that something you might allow jurors to do? Would you experiment with something like that?
So let Judge Goldstein go.
Judge Goldstein.
We haven't talked much. He hasn't talked to us.
Oh, I haven't toyed with that idea. That kind of makes me a little bit uncomfortable since you have the burden of proof issue and waiting to hear everything because there's 2 sides to every scenario. I have thought about letting them ask questions.
That was literally gonna be my follow-up. So,
I've thought about that, but having them submit them to me in writing so that I can ask the questions or discuss it with the lawyers and have those questions asked.
were any of these jurors, were you allowed to submit questions, written questions to witnesses? No. Is that something you wish you could have done?
Yes, I think so.
Why do you think you would have liked to ask questions of some witnesses?
Well, I think there's a lot of times where you keep wondering why something isn't asked, and neither side asks it, and you're like, okay, is that the smoking gun? And if we could have asked the question, it would have probably helped us.
Yeah, and there were holes, I felt in our case, there were holes in the history that would have been good to have clear.
And I had some questions that I felt like if I could ask, it would just cut to the chase. Just
You could have spent the whole thing up.
I would say that when I was on the bench, I became a great advocate of allowing jurors to ask questions, and I did it in every case. I was a skeptic before I first tried it, but I found that it accomplished the purpose we were talking about. It really kept the jurors engaged more in the case, made them feel, I think, more part of the process, and I really think it helped the attorneys focus their arguments in their case, and the jurors asked really intelligent questions. If anybody ever doubted whether the jury's getting it or not, these were complex patent cases, and they would, more times than not, go right to the heart of the case. I would be a little disinclined about ongoing deliberations because the jury's not received the charge and instructions yet, and I think it would run the risk of jurors not keeping an open mind, because once you take a position in front of other people, there's a tendency to want to hang on to that position, especially if it gets into a disagreement.
Absolutely.
Can I say this? On a few of the longer cases, and I don't know if I recommended this in Cornerstone, I've asked the attorneys if they would agree, because it's not something that I think is necessarily allowed by Texas law. And so I think I've only had one case in situations where I've asked, which is not most cases, where the attorneys actually agreed, and we did have questions. And so I'm curious, it'd be interesting to see why attorneys don't want jurors to ask questions, because or is that a thing? Do they not want them to ask questions? But I've had a number of cases where one side will agree, and then the other side, I think, reflexively will not agree because the other side did agree. And in fact, almost every time I've asked them,
Lawyers won't agree on anything.
Yeah, so they figure there's some reason the other side wants to do it, so that must hurt them. But I think it would be a good idea, but I'm always leery if one side is objecting.
Can I ask another question? And I know I keep asking questions about deliberation. That's just an interest of mine. For those of you who deliberated, did you send any notes back to the judge? And if you did, do you feel like the note was adequately responded to? And if not, why not? And how could the judge have responded better to your note?
My answer is no, we didn't.
No, okay.
Any of the jurors in the audience, did you guys ever ask questions?
I think we didn't physically write a note, but we asked, because we were uncomfortable with the individuals involved on the plaintiff side, we asked to be let out through the garage and not go in front of them. And we were accommodated with that.
Sounds like your case was very interesting.
It was interesting.
So, kind of moving towards that, you finished deliberations, the case has ended. You spoke a little bit about it earlier, about once the case ended, how you felt. Did any of the jurors feel like, did you feel like your voice was heard? Did you feel like through the deliberative process, we had unfortunately she already left, we had an earlier juror who spoke wonderfully about this, and she felt like everyone had participated. Would you guys agree? Did you find that it was contentious and difficult, but overall satisfying? Could you talk a little bit about how you felt after you'd reached a verdict? Paula.
Well, with that being said, I feel like, yes, I did contribute, and everybody in the room's opinion was taken into account, and we did ask everybody to kind of like weigh in on the decision of how they felt to make sure that we were all on the same page.
I think that would be jurors in the audience.
Oh, yes, please. Let's do the mic again, though, if that's...
Yes.
Yeah, for our jury, I can't remember who set up, but we actually had a really good system for making sure that everyone's voice was heard. I think we'd throw a question out there, and then, if anyone had something to respond to it, they'd raise their hands. And then we had another juror who's basically taking note of who's raising their hands, so we could make sure that we got everyone's opinion. So, yeah, I think everyone, who needed to be heard definitely got their voice heard. So I don't know about Carolyn, if you feel the same way, but it was with the system that we had set up, it was actually a pretty smooth process.
In your complicated case, did anybody have trouble, and up here as well, with the instructions? Was there debate among what maybe the instructions meant, or understanding were there terms that maybe were confusing in the deliberative process that you wish had been? One of the innovations that the Civil Jury Project is proposing is more plain language in jury instructions. Make it easier for the jury to understand precisely what they're being asked to decide. Did anybody have any trouble with that aspect during deliberations?
I don't recall that, but any additional plain language would definitely help. Legalese is not the specialty of regular folk.
Judge Hoffman discussed all the instructions with us and made it pretty straightforward, clarified some things so that when we got in there, if we did come up with a question, there were several of us that went, no, this is exactly what he said. So it went pretty smoothly.
And the same with Judge Goldstein. She was very thorough and point by case, and line by line. If we didn't understand something, she went over it again. But she was very thorough with the information that we were given.
Fantastic. Well, then I guess sort of wrapping up, I'd just ask the people who are on the panel if you just had a few comments maybe that you'd like to make, something that I didn't bring up, something that you'd like the attorneys or the judges in the room to hear about your jury experience, what could have been done to make it better, or what you really enjoyed. Maybe we'll start on this side. Claire?
I was an alternate juror number 1, so that could have been very frustrating after you spend 3 weeks and then you know nothing. Fortunately, we had a great jury, and when after they had my phone number. So as soon as they came up with a verdict, Carolyn there called me and said, "We've reached a verdict." Of course, I said, "So what did you decide?" She said, "We're not telling you until you come down and have lunch with us." So Gary was out of town, so he didn't get the benefit of this, but so all 13 of us sat and had lunch, and we hashed out, and we said, I mean, we just went over all these. Can you believe this, or that picture we saw, or this? And it was so helpful, because after you've really invested 3 weeks of your life in a trial, I mean, I was dreaming about it at night, because it was complicated. Well, there were lots of pieces to that case. So for complicated cases, that really helped me.
That positive.
Well, just to be able to get it out, because, you know, I couldn't talk to my family, couldn't talk to anybody about it. So for 3 weeks, it's just building up, and you want to just say something, and you want to tell somebody, and to be able to have the group that went through it with you talk about it. And I think it helped the others too, that even though they deliberated, that you got to talk about some of the funny things, some of the crazy things, some of the weird things that went on. So.
May I ask you a question?
Mm-hmm.
You mentioned in response to another question that after you got past the drama, there was a lot of drama. Now, you don't necessarily have to tell us what it was, but did you think it was purposely created drama? What was it that gave you the difficulty with it?
Well, I thought perhaps.
It was just overly dramatic in terms of
Yes.
the presentation?
Yes.
And you found that offensive?
Well, I just wanted it not helpful necessarily. Yeah.
Can I just make a comment on that? I don't want attorneys to take this case was extremely unusual. I'll just say that. And the presentation style was extremely unusual. So it does not, she's being very kind in her comments because I think drama can be good. I think it's sometimes useful. In this case, though, it was, I mean, I've never had a jury ever asked to be escorted out of the courthouse before because they didn't want to talk to one side. So it was an unusual trial. So from that standpoint, you can definitely take it too far, and this was a good example. I think, would you agree with that? That it would.
I'd just like to take the opportunity to ask the other jurors that were on the Cornerstone case if they would like to say something, since I've been blessed to be up here.
Oh, no, come on.
Oh, come on, stand up,
You
say
need
something.
to say something.
Come on, stand up and say something.
You don't want to say anything? Okay. All right. Sorry.
Okay. Well, we never got to the deliberation point, so it was kind of like bittersweet, because we never got the opportunity to discuss it in the jury room with each other and see which side each of us stood on. And so it was kind of, it was a deflation at the end of the trial. Plus, we didn't really find out how it was settled. It was settled, but we didn't know how. So
that was something frustrating.
we went through 9 weeks, and then it's kind of like 9 weeks and you deliver a baby, but no one lets you see the baby and you don't know what sex it is, you know, so it's kind of like.
Absolutely. Gary, do you have any closing remarks you'd like to make?
Yes, I would like to thank Judge Hoffman for being a kind judge and keeping it real and down to earth. I know it's he's got a job to do, and he's got to keep the law, but he made it real, and he gave us, like Claire mentioned, he gave us blankets, and he was very attentive to the jury's needs, and I thought that was great, and it made us more relaxed and comfortable.
That's great. That's great. Haquela, do you have anything you'd like to say?
I would just like to piggyback off of what Mr. Cook said, the same for Judge Goldstein. She was very attentive to our needs, and it was a wonderful one-day experience.
Well, then that's it, but we really want to thank all of our jurors who showed up today and our judges who agreed to be on the panel.
Thank you. I enjoyed it. Carolyn just said your name's up
Jurors
there.
would like to talk to me afterwards. We'll be having a video recording where we can discuss some of the things that you think would be better or changed if you didn't feel comfortable doing so in front of the audience. So thank you again.
Every time I fix something sweet to eat.
Thanks for not to meet you. Thank you for your.